Afternoon. This is Mike Haber, and I want to welcome you to At Your Service with Haber and Martinez. Although, once again, it's only kind of at your service with Haber because Martinez is not here in person. I'm sure he's here in spirit. He had a conflict and couldn't make it today. So you're stuck with me, and I apologize in advance for that. But you're not just stuck with me. I'm not the only guy you're going to see on this screen. We are privileged and honored and proud to have Dr. Michael Brannon with us. Dr. Brannon is a guest who's appearing, and he is a forensic expert in the field of psychology. Actually, he's been qualified as an expert in many fields, not just psychology or forensic psychology, but a litany of different subsections and subcategories, all sorts of real interesting things that we'll be able to talk about with him. And hopefully he can share some real interesting and entertaining and educational real world historical examples and situations and illustrations of things that he's been involved in. Every one of you has probably seen CSI or Bull or those types of TV shows. And really, that's where this whole idea of forensic psychology exploded. So we're going to bring in our real world forensic expert right now. And I'd like you to join me in welcoming Dr. Michael Brannon. Doc, thank you so much for coming on set.
Oh, sure. Thank you, Michael. I appreciate the invitation.
So this is the 11th show that we've done, but it's the first one that we're doing using Zoom. So I have to thank you for not only appearing, but allowing us to explore and open up our horizons to doing this show on Zoom as well, because it gives us obviously a much larger pool of guests to choose from.
Sure.
So
I'm glad to
thank you.
do it. Yeah, Zoom has been my life for the last 19 months. So I've learned to make Zoom my best friend here throughout these months, actually.
I want to jump back and ask you about that in a little bit. Remind me, because it's an interesting dichotomy about the difference between appearing in a courtroom via Zoom versus appearing in person.
Right. Right. Just think about that, Michael. I mean, personal contact is what your business and my business is all about. So seeing someone face to face, talking to prosecutors or defense attorneys in the courtroom, talking to your clients there, to a judge, me doing evaluations, we do a very personal face to face, up close kind of contact. And having to relearn some of those skills through Zoom, through the separation of a computer, has really been a very, very different experience for me. And I know for the people who I speak to.
I guess it's probably even worse being in person if you're wearing a mask, right? Because facial expressions are non-existent. It's very difficult to adjudicate a person's credibility through a mask as opposed to looking at them, in their entirety.
That's a great point, because many of the jails now are open again and many of the courtrooms are open again. So I'm actually doing evaluations back in the jails again. So seeing someone in a mask when they're watching me in a mask as well reduces my ability to see some of those things and see some of those reactions, but they in turn don't see when I'm joking or I'm smiling or nodding my head in approval. So some of those cues that we rely on or depend upon oftentimes are missing when you see emotionally distressed people in the jail setting. So you're right. It's caused us to really adjust in so many different ways.
Well, again, I want to come back to that, but let's spend a moment talking about what you do, because, I kind of promoted a little bit, but I'm sure you can do a much better job explaining to the folks, what is a forensic psychologist? Why do we need you? What is your function?
So when you opened up initially, Michael, you were talking about how popular it is, CSI and all these different TV shows and all this emphasis on forensic psychology. It's gotten to the point where when I go to social outings, I tell people I sell aluminum siding because I don't want them to ask me a million questions about forensic psychology. I mean, 100 is good, but when they start to ask me all night long about what I do and how I do it, after a while, you start to think, well, maybe that's not the best thing to talk about.
Unless, of course, you can bill by the hour, and then it's probably not so bad.
They don't appreciate that at social engagements, I found, though. So what happens, Michael, is that my job is basically applying the science of psychology to legal issues. And sometimes they're uncomfortable bedfellows because there's not the same language, and sometimes the way we view the world is very, very different. So applying those principles of the science of psychology to exactly what the court may look for, like, is someone competent to proceed? Or were they insane at the time of an offense? Or are they too dangerous to be released out on bond?
Why don't we hit those? Why don't we hit those 3 points while you bring them up?
Sure.
Um, Competence, sanity, and risk assessment, because those are three really great topics to talk about.
Right. And those are three that are really kind of prime investigations for forensic psychologists. I see my job as kind of being a behavioral detective in what I do, and that unlike a clinical psychologist who sits in a room, much like we are right now, and just talking to somebody about their problems or their difficulties, forensic psychology is really considering a lot of different forms of evidence. It's really looking at a lot of different ways of answering a legal question. So when you say competency to proceed, well, there's a good start because that's the most common type of evaluation to go to a forensic psychologist anywhere in the country. I mean, that really has to do with how's the person functionally, psychologically right now as they sit across from you, how are they functioning? And as a result of how they're functioning, are they able to, and we'll break it down into two parts, are they able to A, understand what's going on in the courtroom, and B, assist in their defense by telling their attorney what's going on and giving him relevant information, him or her relevant information. So competency is a here and now. What's going on right now with this person? Do they have low IQ? Do they have neurological problems? Do they have psychological problems that interfere in their ability to be able to participate in a fair legal process?
And that would juxtapose with sanity, which is not what's happening today, but what happened at the time of the offense, right?
Yes, sir. It's a Michael, it's a retrospective. So that's even more detective work because what you're doing is you're looking back at some point in the past, and sometimes it's years in the past that you're looking. Hopefully not, but sometimes it is. Other times it's a year or a month or a day, but it's always more difficult because you need what? You need more evidence to be able to do that. More
And the,
witness statements, more individual records. You need more of an idea of how they were doing then, not now.
so how do you get a hold of that material? How do you the guy with the PhD get a hold of that historical data?
So here's what you need to do. You have to ask a lot of questions. So you have to say to somebody, who was around you at that time? Who was talking to you at that time? Who were you confiding with? Did you have a boss? Did you have a relationship? Were you seeing a physician? Did you have any mental health assistance? Were you in a hospital? So anyone that was around that person or any records that you can glean for that time period is extremely important. Were they placed in a jail or in a hospital right after the offense behavior? Did it take a while to catch up to them? All those things are important. So it starts with good questioning because you can't do what? You can't rely just on what the person tells you because they have an interest in how this comes out. So they may have a bias in terms of what they're reporting to you. So you ask good questions, you ask everybody in terms of what they have, and then you go out and you try to find those people or with the assistance of a defense attorney, try to track those people or those records down to be able to assist you with that analysis.
But if you're hired by a defense attorney, you're an advocate in a way, aren't you?
So you're not. So our ethical standards as psychologists tell us that no matter who we work for, we're supposed to give the same unbiased, fair opinion. The advocates are really the prosecutors and defense attorneys. But as an expert, a lot of times, if you're doing your job right, you're going to make the people who hired you unhappy. And the reason why is because you're not necessarily looking at the case the way they do in forms of their advocacy. What you're doing is you're trying to get a fair and empirically based evaluation that's comprehensive, that answers the legal question. So again, even though it may run counter to what the person who hired you wants you to do, your role is not one of advocacy. Your role is one of objectivity and looking at things from an empirical basis.
Now you get hired by both sides, right? I mean, you sometimes you work for the government, sometimes you work for the defense, correct?
Yes, Michael, I do. Sometimes I'm hired by the courts, sometimes by prosecutors, both federal and state, and sometimes by defense attorneys. So I've been fortunate enough in my career to be able to get it from all different sides, which I think is really the mark that we strive for. Is if you have respect. I mean, I don't always like your opinion, but if you have respect that people, at least on both sides, think you're going to be honest, and that the bench thinks that as well, then you tend to be able to get referrals from all of those groups. For us, the answer is how do we get it right? It's not always necessarily how do we make somebody happy.
So let's go back to competence for a minute because competence can come up in any of three ways. Either the court on its own initiative can say, you know what, I think somebody needs to check this guy out or this gal out because there may be an issue here, or the defense attorney may raise it, whether it's factual or strategic, or the prosecutor might bring it up for any of a variety of reasons, correct?
Right, Michael. And you picked out the three most common ones, but there's a fourth one. The fourth one is if you send an evaluator in, let's say to do an evaluation for mitigation. And in the course of that, I see some things that make me think this person is not getting it. The fourth way may be that the expert, whether he's hired by he or she is hired by the state, or whether they're hired by the defense to go back and say, listen, you sent me to do X, but let me tell you about why. I'm concerned, and I just want to pass that on to you. You do whatever you want, but as an officer of the court, I want to pass that on to you. So those are the most common ways that competency evaluations come about.
Now, if you get hired, if you get appointed by the court, the judge says, Dr. Brannon, I'd like you to come in and take a look at this defendant and give me an opinion as to their competence. You're paid by the court, correct?
Correct. Yes.
And so that would truly be a non-biased position because you're not working for one side or the other. You're there as a neutral reporter to the judge, correct?
Yes, the statute even says that. It talks about court-appointed evaluators. It's under 3.210, where they talk about court-appointed evaluators conducting competency evaluations. And even though the defense can hire their own experts to do competencies, really the most weight on most occasions is given to the court-appointed experts because bias is something that is very important in our profession. So who do you work for the most? How often do you work for them? And even how much money do you make working for certain agencies, certain attorneys, certain state attorneys' offices? All those things are relevant issues that can affect the objectivity and the level of bias of an examiner.
Well, that's kind of where I was going with it again, because ultimately at some point down the road, whether it's a competency hearing or it's during a trial or a sentencing or what have you, you're going to be subject to examination by both sides. The court's not going to question you. You're going to get questioned by a prosecutor, you're going to get questioned by a defense attorney, and depending upon who you're working for, you got to expect one or the other is going to go at you, trying to allege or try and suggest some perception of bias or prejudice, that you have a financial interest or some personal relationship, or what have you. They're going to try and attack your credibility any way they can. If they can't attack your opinion, they've got to go after the person, right?
Yes, Michael, and most experts are very vulnerable in that way, in that, you go into this oftentimes with your own personal biases, like I want to help people out. So if that's your bias going in, whether you acknowledge it or not, you're more likely to wind up doing defense favored evaluations. If you go into it with kind of a criminal justice mindset that people do bad things and society needs to have more law and order, then you tend to be more of a state expert. And then if you're doing your job, you try to balance both of those sides and check and monitor your own bias. We've been very critical in my profession and done a lot of research in the area of bias. We have a name for it. It's called affiliation bias or allegiance bias. And we've really found out that we're much more biased than we think we are. We need to work even harder to make sure that we don't have a blind eye to data and only pay attention to the things that support the opinion of the person who hires us.
Interesting. So we've got competency again, just jumping backwards. That's in the moment right now. Can this individual meaningfully participate in his or her own defense? And are they going to disrupt the courtroom during the process? Basically, those are the two big issues.
Yes.
Let's jump over to insanity for a minute, because I think most people, if you probably ask 10 random people down the street, they know the word insanity or insanity defense, and they have perceptions about it and probably never thought too much about competence. Sanity always seems to be the bigger picture item. And we know empirically that it's a very small percentage of cases that actually employ insanity. We may talk about it, but to actually go through with it and try and put forth an insanity defense it's a minuscule percentage. And then it's a minuscule percentage of that minuscule percentage that it's actually is successful in getting a NGI verdict, right?
Well, you said it better than I could, so I'll say it second best for this show. But yes, you're absolutely right on all those points, Michael. I mean, people have a misconception that the sanity defense is used a lot to get guilty people off or people who have done dangerous acts off in the courtroom. But it's not used very often, less than 1% of the time in cases. And when it is used, it's effective only about a tenth of those 1% of the times. Most of the insanity cases are stipulated on, actually, but the ones that actually go to trial, more often than not, lose. There's a number of hypotheses as to why, but most of them lose.
Well, throw one or two at us, would you?
Well, one is that juries don't like them. Juries don't like the idea, even when they're given jury instructions, of somebody who could be dangerous to other people or could commit crimes against other people being excused because they have mental health issues or problems or emotional difficulties, especially if they're esoteric ones like dissociative identity disorder, where a person has many different personalities, or they're hearing voices of the devil telling them to do certain things, all things that can happen. But juries tend not to like that. I shouldn't castigate all juries, but I'm saying many people in jury pools don't like that. So even given the instructions, they oftentimes are reluctant to let somebody off, especially on serious crimes, because of mental health reasons.
It's funny because that reminds me a little bit of jumping forward again, and I'll come back, but statutory mitigation. And so that the folks understand, if you're found guilty of a crime, you go to a sentencing hearing. And during sentencing, you're entitled as the defense to present evidence to the court to try and mitigate the sentence. In other words, to bring it down from below the guidelines or to the lowest possible point that you can. And so as defense attorneys, one of the things that we like to do, if we can, if it's appropriate, is to bring in somebody like Dr. Brannon, a forensic psychologist, to give the court a good, solid statutory reason, such as the individual suffers from a major mental illness and is amenable to treatment. So it always strikes me as ironic that, I could get a client who you could come forward and say, Mike, good news, DSM, where are we now? 5R, 6,
You're
7,
on five. Yeah, you're on
I,
five, soon to be
DS,
revised, right?
DSM 5R, we've got him. He's bipolar. Great news. We can lock him into a bona fide mental disorder. But then what am I supposed to argue to the judge? Let my bipolar client out so that, hopefully he can take his meds and not, wind up back in front of you. It's a two-edged sword, right?
It is. And the DSM-5, matter of fact, all of the versions from DSM-2 on have provisions in them. I even have the page memorized because it's used so often. It's page 25 of the DSM-5, and really talks about a diagnosis is not synonymous with any legal standard. So they're very careful about how diagnoses are used and then in what context. So in what you're talking about, mitigation, you really have to be able to say not only the person has a diagnosis, but what are we going to do about it? Because what's the judge interested in? The judge is interested in, I don't want this man or woman to go commit another crime again. I want to reduce their risk of reoffending. So what's that defense attorney and that doctor going to tell me that's going to reduce reoffending so I'm not looking at this person again? So that's the important thing, the treatment plan. So not only do they have this diagnosis, but what are we going to do about it to lower the possibility of any kind of recidivism? That's, I think, the key. Another thing I wanted to say too on that, Mike, is that there used to be, and I know that you're old enough and I am too to remember this. In the very beginning, there used to be years ago, decades ago, there used to be what's called diminished capacity. So a defense attorney like yourself could actually go in and say, my client has schizophrenia, but because the standard for insanity, which I know we'll talk about, is so stringent and so difficult in the state of Florida, that I just want the court to know that this person's schizophrenia directly impacted their ability to control their behavior at the time of this incident. I know it doesn't meet the criteria for insanity, but he was significantly impaired, and I'm looking to the court to give him a break because of that. That's gone off the table for decades now. And many people in my profession think that that's an omission that should be corrected.
Well, I guess, and that dovetails also into the voluntary intoxication defense, which, also for decades now has basically been squashed. The fact that you're under the influence doesn't in any way mitigate criminal liability.
Correct. Right. There's many defenses that have been removed, which previously were very effective at getting people into treatment programs, getting people the kind of medication that they needed, getting them into residential dual diagnosis programs, which in the end product reduces recidivism. There's less victims and less people in front of the court. So if you don't have a treatment-minded, mentality when you approach these situations, you warehouse people in jail, and as a result of that, they come back out and reoffend.
But there's another key component to that, and that is the amenability to treatment. Because if the client's not willing to do the job, it really doesn't matter what you and I say, right? I mean, we have to have a client that's with the program.
So boy, that's a tough one, Michael. And let me tell you that there is no scale that we have to empirically measure. We have tests for everything as psychologists. We have hundreds and hundreds of tests, but there's no scale that we have that can assess amenability or motivation for treatment. We don't know.
but you and I have a scale, and most experienced defense attorneys and most experienced mental health professionals have their own internal mechanism. It's like we're a walking, talking polygraph, right? In a way, we know when we're being bullshitted by a client. We know when somebody's telling us, not always, but more often than not, they're telling us what they think we want to hear or what they think is in their best interests, as opposed to when they're being genuine.
So I haven't talked to very many people, Michael, who I'm interviewing for mitigation who didn't tell me they wanted to go into a program, as opposed to going to prison. So that's the majority, if not all of the people. Maybe one or two didn't tell me that, and they were so mentally ill they didn't recognize that was in their best interest. But in terms of figuring it out, I've tried throughout my years to become more humble about my abilities to be able to discern when people really want to get treatment or when they're really mentally ill, because I've had a chance now to see people who I really believed were motivated for treatment who weren't so motivated, and people who looked very mentally ill to me and looked that way on testing too, who weren't so mentally ill. So I think that it really allows us to really kind of be humble and to be critical of our own work and to have higher levels of certainty in terms of evidence when we do our work.
I definitely would agree with that, but I still maintain, after 30 years, I'm pretty good at picking out the folks who are sincere
Right.
versus the folks who aren't.
So I'll go as far as saying I'm better at somebody who's only been doing it a few years. But I think you always have to keep your eye on the target, that it's clinical judgment, and there's wide margins of error in clinical judgment sometimes. We're always safer when we have some evaluative method to be able to anchor our opinion in. But when we're giving pure clinical judgment, although we may be more accurate than not, there's still a lot of dolphin that we catch when we're trying to get tuna.
Good analogy. I like that one. So for treatment purposes, when we're talking about dual diagnosis, we're talking about somebody who's got a mental health issue as well as an addiction issue. And part of the problem that I've seen with addiction, and I mean, this is just a repetitive, natural occurrence, is that it in and of itself is a disease that many people, if not most people, simply can't control, notwithstanding their desire to do so. So I know I've represented more people than I care to recall who have been completely amenable to treatment, who have wanted it, nothing more than that, only to fall back off the wagon again, given so much time and opportunity after the fact. So you have this kind of vicious cycle when it comes to addiction that you can't necessarily get around with all the treatment in the world.
So, Michael, you could have done this show by yourself, because with all your years of experience, you're so right on target. So let me just add something. Instead of trying to improve on what you said, let me just try to add something. So in addition, think about how the criminal justice system works. Like when judges make decisions, if somebody relapses, that's a sign that they violated their probation, need to be punished more. But in the recovery movement, when you're working with people who are addicts, like you have in terms of your legal practice and I have in terms of my clinical practices, we realize that relapse is part of the process. That's what people do when they have a disease. That's what people do when they have addiction, is that they relapse. And that's, you learn from that experience. You move forward, you get more treatment. And that really tells you where you're at in the treatment process. But that's not a sign that the person should be punished more. It's a matter of how do we change and adapt treatment, recognizing this is a normal step of this highly addictive behavior that's likely to reoccur again. If we were betting people, we would bet that everybody who has an addiction will relapse. We'd win a lot of money making that bet, because most people relapse many, many, many times. It's just a part of the treatment process.
So let me jump backwards to, we talked a little about competence. We talked a little bit about sanity, but I want to go back to pre-arrest. So a lot of times in my practice, I'll have somebody who I know is at a point where they're teetering on the edge. Somebody, an old client that I've represented, perhaps I'll get a call from a family member that says, hey, Bolo, my husband or my wife is about to, they're drinking again, they're using again, they're staying out all night, whatever. I will try and intervene if I can, if I'm retained to do it, by putting them proactively back into treatment, right? So there's a mechanism for me there. And a lot of times when I have a case like that, I will call you or one of your colleagues and say, listen, I need you on board right now, because I know this is going to wind up in a courtroom at some point in time. Like, let's say, for example, I've got a client who's on DUI probation, and I get a call from the spouse that says, my husband or my wife got absolutely hammered tonight, tried to take the keys and leave. I had to take the keys and hide them, blah, 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 blah. I want to put this person in treatment immediately. But in order for me to do that, I've got a problem, right? They're already on probation. So how am I
Right.
going to throw them in inpatient treatment without their probation officer finding out? And that's a tacit admission that they've been violating their probation. So it's a very delicate dance that we have to take on the defense side to either not cue in the state or to bring in a Dr. Brannon to be able to work with us proactively to go to the state and say, listen, this is what we're doing. This is why we're doing it. And then I want you to help me to smooth over those edges and get the
Right.
state to come on board, right?
Right, Michael. I mean, we're doing better. I mean, we have drug courts now, specialty area courts. So we're doing better. But the thinking that you're talking about is still around. It's still that this person broke their community control or they violated their probation. And so getting and educating people, judges, prosecutors. I mean, when I lecture at the judges conferences, I always talk about these kinds of issues, about what you can expect in terms of reoffending behavior or violating behavior from people who have mental health and substance abuse issues. So part of it is just education, but part of it is changing the system so that there's more kinds of courts like mental health courts and substance abuse courts who understand that's how people are going to behave when they have those kinds of problems and difficulties.
But
And to
even
be able
with,
to put them
I'm
in
sorry, I
better
didn't mean to cut
positions.
you off.
Oh, no problem. And to put them in better positions in order to be able to get the kind of treatment that they need.
Even with drug courts, though, they tend to have zero tolerance policies. So, you put somebody in drug court, they have a dirty urine 3 months in, they're booted out of the program.
Right. And that is a problem. They're getting better, though. They're certainly getting educated. I can speak to what happens here in Broward and Palm Beach, but they're getting better in terms of but it's a slow process. The change is slow for them to understand that. They need some markers in terms of what violates a person's probation. So in this case, when someone has drug charges and they violate with drugs, it's hard for courts to get away from seeing that as a behavior that a person volitionally engages in,
Right.
that they've done by choice and will, as opposed to it's part of an addiction.
They tend to look at it like a slap in the face, like it's a
Yes,
complete slap in the face to the criminal justice system. And in
right.
some instances, it may very well be. They may not be wrong. But I find if you jump to the other end of the spectrum, now you've got sentenced individuals. Where's the help they're getting in the prison system? Where's the help they're getting in the jail system?
First thing that gets cut, Michael, of course, is mental health and substance abuse programs. So whenever there's funding cuts in jails, those are the first things to go. So they return back to a punishment model, as opposed to a model which helps to rehabilitate people. So even though there's some cursory services, and I'd certainly get some argument from some of the people who work in the system, and there's some fine people that work in the correctional systems in
Absolutely.
Florida. However, they're overloaded. They're tremendously, sometimes there's one psychologist for several different correctional institutes. So the amount of services that they can give and evaluations and mental health as well as substance abuse services is greatly lessened by the amount of work that they have. Remember this is a startling figure, and this has been this way for over 25 years. There's more people since deinstitutionalization, allowing more and more people out of institutions. There's more people with mental health problems in jails and in prisons than in all mental health facilities in the country. So you're treating more people in jail and prison with mental health problems, or at least should be treating them. But there's more of those people with a diagnosis than in all psychiatric hospitals and mental health facilities. That's startling.
Understaffed, underfunded, and not well thought out. We don't
Sure.
have vocational training in prison either, which makes absolutely no sense to me. I know that's another topic for another show, but it just seems to me, again, you've got people locked up for a period of years, and you're doing nothing to make them more well-rounded when they come out years later. They don't have a
Yes.
trade, they don't have a craft, they don't have an education, they don't have a shot, basically. Why
And
would you not want to focus that energy? Why would you not want to create vocational training? Why would you not want to really push hard? I mean, incentivize. You can even incentivize it, right? I mean, give them extra gain time for meaningfully participating, right? Not just
right.
going through the hoops, but somebody who goes and gets his GED while they're sitting in prison, somebody who gets an AA or a BA while sitting in prison, those people ought to get something out of it other than the degree. They don't have
Sure.
to do that.
Social control becomes the primary interest as opposed to rehabilitation.
Well, and punishment.
Right, right. And if there isn't a healthy blend of those factors, the person winds up coming out worse, reoffending. It becomes the revolving door. So, and a lot of times too, it's just educating people, as I said before, as to what works best. It's long-term thinking and planning as opposed to short-term. Let's keep them locked up so they don't hurt anyone else, as opposed to let's prevent them when this person's eventually released from here. Let's give them some hope. Let's give them some, ideas about how their life can be different. Let's let them feel positive, optimistic, and like they're moving in the right direction. Hope is a critical element because when you don't give somebody anything other than just sitting around all day in correctional settings, they lose hope. They feel helpless and hopeless. And as a result, they come back out and they're worse than they were when they went in.
Sounds like we ought to be giving this lecture to the Florida legislature.
It's been given. These
Yeah.
lectures have been given over and over again, but
Not with a shovel.
yeah, I know. But what you hear in return, Michael, is that there isn't the funding to do that. That there's, they're low on the amount of hires that they have in low paying jobs in correctional institutes and just in terms of guards and deputies there and social control agents. So when you hear that, that becomes their primary focus. So this is not new, what we're talking about. We're veterans who have been around for decades. So we've seen this happen again and again, and we're banging our fist against the wall and screaming, but other people have done that as well.
Well, at least we're not the first ones to try and roll the square wheel. So
Right.
let me ask you about pre-arrest stuff again on the flip side, because on the defense side, that's one of the main ways that I would come in, right? I am anticipating a problem and I'm troubleshooting it in advance and I'm putting in place strategizing a team to put in place to deal with it. What about the government? Do they ever come to you proactively? Does the prosecution ever reach out to you before they file a case? Have you ever gotten a call from a prosecutor that says, Dr. Brannon, we're pre-filing a case right now, and we have some questions about the confession, or we have some questions about the integrity of our eyewitness identification. Could you take a look at this and give us your opinion? Again, I'm talking about pre-arrest. I know this happens post-arrest, but before pre-information or indictment, rather. So it could be post-arrest, but before they file formal charges. Does the prosecutor ever reach out to you and say, Doc, take a look at this and give us your thoughts?
So that they do, Michael, but it's really individual as opposed to departments. Like I couldn't say Broward does that more than Dade, does that more than West Palm Beach. It's really the individual prosecutor. So some are very forward thinking in that way. Some prosecutors have questions from the very beginning and will reach out to you even just to get some consultation by phone, or, hey, listen to this child interview, this forensic interview. Or look at this confession, or look at this person's behavior on the police body cam when he was being arrested. So all of those things sometimes come to fruition with some prosecutors. But of course, you're right. After they are arrested, it's more likely for a defense attorney to call and say, hey, take a look at these very same items. But it does happen.
Let's talk about that a little bit, because those are three really, good issues. Obviously eyewitness identification is huge. How many cases involve an eyewitness ID? The police are almost never involved. I mean, now I guess you have much more in terms of surveillance and, just people on the streets with their own iPhones and stuff. But still, eyewitness ID is a huge thing. And we know that memory is fallible, and we know that people have biases and prejudices that they're not even aware of that affect memory. And that can certainly affect eyewitness testimony. There's study after study and incident after incident of false eyewitness identifications that are subsequently overturned by DNA evidence, which completely exonerate the individual. So we have eyewitness ID is a real good one to talk about. And of course, child testimony is great too, because, same thing with kids. A lot of times kids tell you what they think you want to hear. Sometimes they tell you what they think that they know or want to believe. They're just not old enough to differentiate or distinguish between reality and fantasy, or the concept of telling the truth versus, getting a reward for saying whatever it is that they say versus a punishment for saying something else.
So you make a great point in that just this morning, I have two wonderful students who are helping me out with a false confession case, or potentially a false confession case. And many of those elements are there. And if you think back to when we started in our respective careers, Michael, the common belief was if someone admitted they did something horrible, they must have done it, because no one in their right mind would say they did something like kill somebody if they didn't really do it, no matter what, because you think to yourself, well, I'd never say I killed somebody or I stole that money if I didn't really do it. But then science came along and taught us that there's things that can happen that can get people who have never done anything at all to actually admit that they did that. Or take child interviews. We used to think when we started off, Michael, the prevailing thought was children don't lie about this kind of stuff. If they say they were abused, their memories are good for this. They're not going to forget something that traumatic. If they say something bad happened to them, it happened. You shouldn't question these children. But then science came along. And we learn that there's different things that can happen in interviews and even before the forensic interviews that can alter and shape the way someone remembers something. And sometimes there's some factors that influence them even to saying things that never really happened at all. So yeah, science has really taught us some different things, not just DNA on cases, but on eyewitness identification cases, false confession cases, child witness cases. We know more than we did before. The science has guided us.
How do you approach a false confession case? How do you, as a forensic psychologist, deal with that?
So this one's easier. I mean, of all the ones that we've talked about so far, this one's easier. You never really know if there's a false confession or not unless somebody, later confesses to it and they have the evidence to support that. But when you're doing this investigation, like we were doing this morning, you never really know that for certain. So what you're looking for is the technique of the officers who are involved. How are they approaching this? There's a technique. I don't want to be too technical because it's boring after a while, but there's a technique called the Reed method. And the Reed method is used by about 90% or more, or some variation of it, in the police departments across the country in asking questions. So based upon how questions are asked and how long they're asked, and how directive they are and how often they're repeated, and what kind of situations a person's placed in terms of the choices that they're given, all of those things can result in someone giving either a false confession, a partially false confession, or just a lie to get out of the room. So we do know with false confession cases, the most important variable is what kind of interview technique was used and over what period of time was it used, and what was the condition of that person that they were talking to.
I just got a message from another colleague of yours, Dr. Ralph Richardson, who asked me to say hello to you.
Thank you so much. Wonderful forensic psychologist, one of my
Yes.
amazing colleagues out there. Yes.
He's my local go-to. I had a false confession case a while back where my client was caught during a occupied burglary. Hands, no question, he committed that offense. They got him back to the police station, put him in an interview room, and wound up pinning 13 other unsolved burglaries in the neighborhood on him. And this is going back a while. There was no video. It was audio recorded. So we did have an audio recording of it. And basically, it was a line of direct examination, actually more like cross-examination, of the officer saying, on this day at this location, do you remember entering this address at this time and taking this property? And all it was yes, no answers. And those confessions probably would have all come in, but for the fact that about halfway through this tape recording, the cops, you hear a thud, and the cops start, there's yelling and panic in the audio. And as it turns out, my client had literally blacked out during the middle of this interrogation or confession session or whatever you want to call it, and his head hit the corner of the desk and got cracked open. So they had to call fire rescue, and then of course they wound up suturing him up and cleaning him up and giving him some coffee and then getting right back to it. And ultimately, I was able to bring in a doctor who was able to assist in convincing the state and the court that maybe these alleged confessions were not all that they were cracked up to be. Saying yes isn't enough. Is that a fair statement?
It is, and especially if there's leading questions or close-ended questions or pressure to respond. Like just a repeated question implies to the person who's there in a novel environment with police and concerned over what's going to happen to them as a result. So just let's just take the isolated repeated questions. For all of us, even as children, we know that repeated questions likely means that the person asking it thinks we got it wrong or weren't telling the truth the first time. So if there's a repeated question that's done often enough and directive enough by somebody in authority, a person or many people will have at least the persuasion to try to change or alter or make that person happy or to escape from an uncomfortable situation. That can start the process of admissions to things that didn't necessarily happen. So all of those kinds of techniques in the decades ago, police officers used to beat confessions out of people. They used to physically do things to them and torture them and keep them in rooms for long periods of time or threaten to harm them. Then they learned that psychological techniques were much more powerful. People got over being beaten up. So they learned that by using psychological techniques, they could get good information from people, but those same techniques can sometimes lead to bad outcomes, especially if applied incorrectly. So it's really important to have experts to be able to look at that and say, yeah, they used this technique, but they used it wrong, or the way they applied it to this person caused a negative effect, like a false confession or an admission of some abuse that never really happened, or the identification of somebody who was never there in the first place, who just sort of looked like a reasonable facsimile of this person that really did the crime. So all of the factors that we've looked at in behavioral research now has helped us to be able to form those conclusions and give that information to the court.
Speaking of techniques, I know you said earlier that you've taught at the Judicial College, correct?
Correct. Not at the college, at the conference, judicial
I'm
conference.
sorry, the
Yes.
Judicial Conference. And you've also taught, given training sessions to various state attorneys' offices, correct?
Have, yes.
How
Both
about
state
police?
and defense. Yeah.
How about police departments?
So twice, I've spoken to police departments twice, both on sex offenders, talking about sex offenders, and some of the impact and effect of working and seeing some of these horrible cases that occur. So specialized units both times. So yeah, I've spoken to
So
police departments.
in that capacity, you mean you're doing stuff more like PTSD training for the officers?
Recognizing awareness of the symptoms that occur, because a lot of times police officers are the last ones to be aware of their own functioning and how they're doing, being exposed to terrible things.
Right.
You, me, police officers, we all share in common. We're exposed to a lot of horrible things every single day, and we have to normalize those things in order for us to get through our day. But we see bad things that people either do or are accused of having done to other people. And in order to do that, we have to have a pretty good recognition of how we're functioning and how we're doing, because we're the tool. You're the set of tools. The carpenter has tools that they use. Your tool is Michael Haber, just like my tool is Michael Brannon, et cetera, et cetera. So for police officers, they're their tool that are out there implementing what they see as keeping law and order in the community and making arrests or not making arrests. They have to be aware of when they've been impacted or affected by some horrible event that's occurred out there in the community.
Well, I'm glad that you're out there doing that. And that kind of goes into two different things. But before I go to the second one, I want to get back to training, because we were talking about how they use techniques. Well, you don't just decide one day I'm going to become a police officer and divine these techniques. They're taught to you. So
Correct.
these detectives are trained. They're trained on how to elicit confessions. They're
Yes.
trained on how to set up lineups. They're trained on how to do show ups. And a lot of times their training skews the deck in their favor, correct?
Well, it does, but we're getting better. We have, police chief societies now that have best practices in regards to setting up lineups and identification procedures, reading, identification, instructions. There's a much better way. It's much more scientific now. And if they don't use that, that's one of the points of criticism, that an expert like myself or Dr. Richardson can come in and say, hey, look, they didn't follow the protocol, which is scientifically based. So they are getting much better at that, because
What about with confessions?
well, okay, so they're using the read technique, and if they use it properly, what the research says is they're more likely to get an accurate, confession. But if they don't use it accurately, and in other words, utilize more steps than others, or use it for too long, or incorporate other types of techniques into the read technique, then that can bastardize it to the point where they get a false confession. So you're really looking at, are they adhering to the model that the science says that will get the desired outcome? I also say this, Michael, that as much as we emphasize sometimes that police, don't do the job, every police officer that I've had in every case that I've seen, I believe their intention to go in was to get the right information. They may not have done it the right way, but again, what I've seen in terms of interviews is they're trying to get it right. Every forensic interviewer that I've seen, they're trying to get it right. They're not trying to get it wrong. They just may take shortcuts or incorporate things that they shouldn't do that makes it toxic. But I think people approach these things with the best of intentions, but difficult situations lead them to doing things that the protocols don't call for.
What if they have a subject who's obviously under the influence, or potentially suffers from some mental deficit, be it organic or otherwise.
Yeah, and they a lot of times don't have the specialized training to be able to A, recognize that, and B, to be able to accommodate for that. So
Well,
if
in the case I gave you an example of, I mean, you'd have to be blind, deaf, and stupid to not know that my client was absolutely hammered,
Mhm.
because he was slurring. He was unable to keep his head straight. They had to pump him full of coffee to keep him up. And then when he did pass out and knock his head, they just, all right, patch him up and let's keep going. I mean, these guys should have known better.
Michael, just to tell two quick war stories, very quick. I mean, I've had two different cases, where a person gave a confession after they had been in an automobile accident. Were taking both DUIs. They were the suspect in both of them. They were not only under the influence of alcohol, but they were in the hospital because of their injuries and had pain medications, opioid medications inside of their systems administered by the hospitals in order to reduce their pain prior to surgery. Both of those cases from a hospital bed. I'm sure I've had more than that. I can just think of these two right now. And in both of those, a confession was elicited by police in interviews that ranged anywhere from an hour to 2 hours. And in both of those, neither of those cases was the confession suppressed. So you have a person under the influence of alcohol who's also administered
Incredible.
opioid medications, and neither of those resulted in a suppression of the confession, even though the issue was raised. So,
It's
in my experience, courts are hesitant, judges are hesitant to suppress statements, even under the most extreme of circumstances.
I've had very similar experiences with DUIs, DUI accident cases. You get a person has an automobile accident, their airbags deploy. I don't know if you've ever been in a car accident with airbag deployment. Unfortunately, I was in one, and I mean, it's like being in a war zone. It's really scary. That thing goes off. It's like a sonic boom. Your head is ringing. Powder's all over the place. This shit gets in your ears and your eyes and your mouth. Your adrenaline's going. You don't know whether you're injured or not. It's just a trauma. I mean, that's a very serious trauma to occur physically and psychologically. Yet the officer will show up on the scene, not only assume that you're under the influence, but then they figure they can still give you roadside sobriety exams and it's no big deal, and just another day at the races. And I sit back and look at it and say it's unbelievable. That these officers can look you in the face and say, "No, we considered it. They were fine. It's no problem."
Right. So they're making decisions on the spot, sometimes right, sometimes incorrectly, where in hindsight, you can look at those things and say, that's amazing. How can that possibly have happened or gone down that way? And I think that we have to say that for the most part, people are doing the best they can in circumstances. And I'll take you just a sidelight for a moment. I mean, in forensic interviews, sometimes people with the best training for child sexual abuse or physical abuse cases, sometimes people with the best of training wind up in situations with difficult kids to interview who may have ADHD, who may or may not have been on their medication that day, may be under the influence. And as a result, they abandon their techniques, the things that they learned, and ask directive leading questions and create memories in kids that never really occurred. And people go to jail for that. People get locked up for that. People get convicted for those kinds of things. So I think that's our role as psychologists, and your role as defense attorneys, and I think the role of prosecutors too, to look at that and say, hey, that's not according to the protocol. That is bad technique, and it doesn't make sense. Even though if you did it for the right reasons, now looking at it in retrospect, it doesn't make much sense.
Interesting. Let me ask you, speaking of police, and I think we agree that in our experience, virtually every police officer I've ever come into contact is a citizen that has a job to do, takes their job pretty seriously, and their primary concern is getting home to their own family at the end of their
Yes,
shift. And they know the potential shitstorm that they could be in at any given moment on any given call, so they're hypersensitive to it, as they should be. They could be
right.
shot, they could be killed, they could be crippled, they could be accused of doing something when they did nothing. They're just the continuum of bad shit that could happen to a law enforcement officer never ends. But one of the things I noticed on your curriculum vitae was that you do, and you have been qualified as an expert in police pre-employment screening.
Yes,
And by that, I'm assuming that you have administered what have been accepted as formal psychological examinations of police candidates.
correct.
And
Yes.
so a police department will say to you, Dr. Brannon, we need you to take a look at our incoming crew list or their particular individual and administer, the battery of examinations and clinical interviews that you need to do, and then give us a recommendation, yay, nay, maybe, whatever the case is. I don't know what the vernacular or what your choices are, but I think that's an interesting question. How do you deal with that? I mean, obviously, you're always going to have a bad seed slip through at some point. But how do
Right.
you try and pick them out? How do you try and figure out? I mean, like, for example, myself, putting a badge and a gun in my hand would be a horrible idea by any standard.
I think we could all agree to that.
Yeah. So, but the good news is, Doc, I know it. And unfortunately, a lot of people don't know it, or a lot of people who do know it want to do it anyhow. So I guess it's kind of your responsibility when you're brought in to tackle that, to weed out those, those potential crazies or those potential powder kegs, and find the people who really are stable and responsible enough to be given that type of power and authority.
Now, we could do an hour on this, Michael, so I'm going to give you my brief answer, but we could really do such a long period of time because this has really evolved. I do both pre-employment screening, not as many as I used to, but I do more fitness for duty for police officers now. But so let's look at the.
Let me hang on before you go on. So for fitness for duty, the difference would be pre-employment is, should we hire this guy? Fitness for duty is, they're already a police officer and something happened or there's some cause for concern and we want to make sure that it's okay for this person to be out on the street.
Right.
Maybe they were involved in a shooting, right, or what have you. Some event occurred.
Or some life event. They got a divorce. They, something bad. Their father died. Something bad happened in their life that seems to have had an impact. But yeah, so I mean, this is a person out protecting the public carrying a gun. So let's go to your original question about pre-employment. So that's evolved as well. So originally, when I did those decades ago, what did the psychologist do? Our role was minimal. So we did an MMPI at that point, MMPI 2, a couple of revisions ago. And all they wanted to know from us was, does this person show any signs of any major mental disorder, schizophrenia, bipolar disorder? So you'd interview the person for an hour, you do an MMPI 2, and you'd publish a couple of page report and say, there's no evidence of any major mental disorders. Done. You were through. Because you weren't the decision maker. You were just one little small portion of all this, and your role was almost perfunctory. Now it's really evolved into several day evaluation with multiple tests that are involved, and some things where there's not even tests involved. Like, is this person likely to engage in over-aggressive behavior? Are they likely to have a bias against a person because of their race or gender or sexual identity? So you're asking questions now that the testing is not caught up to yet. So you're trying to use your clinical judgment, like we talked about earlier, to see what's likely to happen. Is this person likely to show up in the news or get fired or do something where they discriminate against somebody just based on one of those characteristics? So the job is much tougher, and the role of forensic psychologists or really psychologists in general, not just forensic, is much more important in that determination now in our current society.
That's really good news. I'm glad to hear that. I'm sure our audience is glad to hear that. Let's talk about the other end of that spectrum, though, the secondary portion where you're called in to deal with an existing police officer who has some sort of a situation that requires you to evaluate them for fitness.
Right, and that ties up a couple of things. There's a couple of topics, like we've so far talked about, how we do this retrospective analysis of somebody's sanity, how we do a here and now evaluation of somebody. But there's certain kinds of evaluations like fitness for duties or risk assessments, which we talked about in the very beginning. They have something in common. And the thing they have in common is that we're really trying to predict how someone will do in the future. So from a risk assessment, is this person likely to be a danger to somebody in the future or sex offend in the future? Or in terms of fitness for duty, not only are they okay now, but we put them back in the job, are they going to be okay weeks, months, years from now? It's hard to predict years. But are they going to be okay in the future if we put them back on the job, or do they need some type of intervention? That's the hardest thing for psychologists, any mental health professionals, psychiatrists, social workers. The hardest thing to do is we don't have a crystal ball. We do have some factors that we know lead to somebody having more problems on the job or being a risk of danger or sexual offending. But those things are just probabilistic. What we're saying is that there's a higher probability with these factors that this person will have a trouble on the job or will reoffend in some violent or sexual way. So we're offering opinions then based upon our projection, our extrapolation from data about what may happen. It's much
And
riskier and more of an error margin.
And you're very careful, because I've had this experience with you where I've actually put you on the witness stand and asked these types of questions. And I know from my own personal experience with you as an expert that you're very careful in couching those opinions in those probability terms and saying, look, I can't tell you the future. I'm not, Madame Cleo here. So, you're not Nostradamus, but I can tell you that, these are certain points that the individual hits that suggest that he's not likely to recidivate, versus these markers which suggest that there's a potential problem coming down the pike.
Sure, judges aren't looking for you to make, predictions. That'd be nice if you could. They're just looking to be on safer ground. So if they're going to give somebody a break and put somebody out on an ankle monitor, is the probability high or low, or is it somewhere in between that this person may reoffend or go show up back on this, alleged victim's doorstep again? So our science allows us to give those kinds of probabilistic statements about, if you release this person, I can't guarantee that they won't do that, but the probability is low based on these 20 risk factors that have been empirically researched and sought out for many, many years and many revisions of risk assessment tools.
An hour is definitely not enough time with you, Doc. It's just not, because we're almost done with an hour. But Tommy, my producer, is telling me we've got a couple of questions that were dialed into us. So I want to at least get one or two of them asked and answered, if at all possible.
Michael, while you're doing that, can I say one thing?
Of course.
I want to acknowledge the debt that we have in forensic psychology to your father, Lenny Haber, who was a pioneer in our field. We have great respect for him, and he really paved the way for all of us here in South Florida. It's really, the work that he did in the legal system when psychiatrists were only the ones recognized as experts in mental health. Your father did an amazing thing for psychologists and kept at it for many, many, many years. So I tip my hat to him, and I want you to know that.
Thank you very much. I really appreciate it. And I have to balance the scales and give equal credit to my mother, because she is every bit the forensic psychologist that my father ever was.
And paved the way, your mother, not only for forensic psychologists, but for women in the field as well, when women weren't respected to do that kind of big boy work at all. So she definitely paved the way. Both of them did amazing things for us and still do in your mom's case.
Thank you very much, Doc. Tommy,
right, so
what do we got?
Here's the first one, and it's a two-parter. What do you like best about your job? What do you like least about it?
All right, so quickly, I can do that in the time that we have. So the best part is it's always different, and you're around smart people. You're around smart attorneys like Michael Haber and many other people who challenge you. Oftentimes, you're on the other side of the case from them, and so it's challenging, and you have to be careful and make sure that you're doing things, by the book, and making sure that you're being fair in your opinion. So being in a stimulating environment that's always different is fun. The most difficult thing is the amount of record review. You have to be sure people's lives oftentimes are on the line, or at least their freedom for long periods of time. And the attorney who hires you or even cross-examines you has to be real sure that you're the kind of expert that's going to do that. So the more tedious things is the sitting back late at night, looking at record after record after record, which, Michael, you can identify with, and making sure you have a comprehensive knowledge and information that helps to support your opinion.
Excellent.
Yeah, here's another one. What do you think students should know about a career in forensic psychology that they may not realize?
Know thyself. This is hard work. I mean, clinical psychology is really hard. Sitting in a room and talking to somebody about problems is really hard, because I did that too. But it's personality based. If you don't like everything that you do being inspected with a microscope by really smart people who are going to question everything you did, even when you did it right, and you're easily bruised by that, don't do this. If you're not detail oriented and have at least decent writing skills, don't do this. If you want to just help out people and be an advocate for people, do clinical work or something else, but know yourself and know when it's not something that's quite right for you. But it's a great profession, and I'm glad that I found it and wouldn't want to do anything else.
This is also along the line of the student question. Is it difficult to find internship experience or get an internship with a forensic psychologist?
Such a funny question, because I've had more good luck with undergraduate students. I have two wonderful undergraduate students with me here, and one even master's level student. And sometimes they outperform even the doctoral level students. It's attitude, it's commitment, it's the things like the yellow brick road that you can't teach. It's attention to detail, it's motivation to do the right thing, it's a passion for the work. It's being interested in getting the right answer, being ethical and honest about what you do. All of those things are important, and you can't teach that. You can teach techniques in school, but you can't teach those other things.
Do we have any more, Tom? Do we have time for one more or no?
Okay. I think you'll be able to answer this relatively quickly. Is your job like what I see on Criminal Minds or other television programs?
Partly. So sometimes it's really exciting and really great, just like Michael will tell you. Sometimes you're in high profile cases and you're there and you're saying, I'm on top of the world. There's TV cameras here and I'm sitting here interacting with these really smart people, interesting people. And then there's other times I'm sitting in a room at 12 o'clock at night on a Saturday reviewing one last document for my testimony on Monday, where I'm asking myself, why are you doing this? Why? So, but it is in some ways like what you see. Not totally, they just get the glamour part, but in some ways, yeah, there is that kind of excitement sometimes.
I wish that we had more time, Doc, because I know there's more questions, and I apologize to everybody. I thank everybody who submitted questions, and I apologize to those of you who we could not get your questions out because we're up against the clock. But Doc, I hope you'll come back again, and we can continue this conversation. I really appreciate your taking the time out of a busy Monday. I know it's not easy. It's a sacrifice. And it was really just wonderful. It's good to see you, even if I have to see you through Zoom. Better that than not at all.
Exactly. It's great to see you, and thanks for the invite, Michael. I really do appreciate it.
It was my great pleasure. I'm sorry that Ed wasn't here to chime in, but I hope that you and I had a dialogue that everybody learned a little something from and enjoyed. And again, Doc, I can't thank you enough. I really appreciate your time and everything you do. And I look forward to seeing you again. And for the rest of the folks out there, I look forward to being at your service next week on episode 12. Doc, be good, my friend.